jam through policy with one party and the other party is saying it's horrible and it's illegitimate, you're not going to be able to sustain it for very long. And so the external and the internal, I think, interact in a way that's troublesome now.
Yes?
Gentlemen, I just wanted to take us to perhaps a longer view on the major thesis, that is the balance of power, the struggle between legislative and executive. It's practically, if not absolutely impossible for us in any time and place to step outside of our system so we can give a view as if we were history itself. But if we look, if you take March 4th, 1933 as a date, it seems clear that the first branch of government has ceded enormous power to the second branch since FDR. All across the board, war making, you name it. I mean, that seems to be the major arc. The other observation is that if you study it's dangerous to announce the lessons of history, but if you look at other systems in other times and places, one of the drumbeats of history seems to be that at a certain point in an arc of the development of great nations and empires, the legislative power, such as it is, however you define that, always cedes power to the executive, including the military. And this seems to be a, if I may, lesson of history. How do we, necessarily focusing on tinkering with this, that, and the other element of our time and place, step back and look at the long view and say, well, the system is or is not an exception to the lessons of history?
I think a very wise set of observations. In our book, we certainly track the development of that executive legislative branch over time and history, and acknowledge the combination of the growth of the administrative state and the national security state have transferred a tremendous amount of discretion and authority to the executive branch. We also learned that there were some matters of policy that needed some degree of insulation from the normal political process. The whole Federal Reserve system is predicated on the basis of, if you want a responsible monetary policy, you better not let Congress legislate it. And there are other areas where we felt we've had to do that. We're about to have another experiment like this in the health arena. That is, it's really wild, but Congress legislates oftentimes specific reimbursements under Medicare of what's covered, what isn't, whether a fee will go up or stay the same or even go down. And this has proven really problematic. There are all kind of bizarre irrationalities. The cutoff of the drugs to help the system compensate for a kidney transplant after 3 years. It's 3 years and you're out, so people can't afford. They then go on dialysis, which costs 10 times as much but is covered indefinitely. I mean, that's one of the irrationalities built into the system. We know we engage in too much diagnostic testing, and we know we follow some procedures for which the overwhelming evidence from research, good research, trials, is that it's at best has no effect, at worst is counterproductive. To have Congress in the middle of making those decisions is to abdicate any chance of getting control of them. So my guess is we're going to be establishing some kind of additional board with some authority to package a set of recommendations and then get an up or down vote in the Congress. There are times when the very nature of the problems you're confronting require some delegation of authority, some insulation. But when you do that, you simply have to have some forms of accountability. You have to structure it such that the electorate can be in a position, if they're mad as hell and think we're going in the wrong direction, can kick a team out of power and make possible a new direction. It's a blunt instrument, but Congress and elections are essential to it so that we get both the periodic elections and then the interventions by Congress. And I think it's possible, even with this view from the sweep of history, to retain that role, to keep power from amassing so overwhelmingly in the executive branch of government.
Yes.
Hi. What would it take politically and legally for Congress to limit or eliminate signing statements, and what's their breadth of power in that regard? And then secondly, in terms of what does the Constitution imply regarding private companies like Diebold having control over the effective count of the vote without allowing access to the mechanisms, including possible corruption of the process?
Well, on the first, you effectively can't stop a president from saying what he wants to say when he signs a law. Most presidents who have done signing statements did not take it to the level that President Bush did. And the problem with President Bush was not just the number of signing statements. It was signing statements basically saying, even as he signed a law, that there were parts of it that he wasn't going to implement because he viewed them as unconstitutional. And there's a direct challenge. I mean, basically, if you don't like a law or believe that a part of it is unconstitutional as a president, your role is to veto that bill, not to selectively choose. And their Congress, to deal with it, really has to use some of its other powers, including the power of the purse, to make it clear that if a president, in effect, oversteps the bounds, there'll be a price to pay. Some of this has to be done informally. So far, the 5 signing statements that President Obama has made haven't raised nearly as many alarm bells. They're more along the lines of previous presidents, but we will have to wait and see. On Diebold, which, by the way, has now gone out of business, and the danger is not Diebold per se, it's that we're now down to basically one voting machine manufacturer, so there's not even any competition. And Congress has to come back in. Tom and I are spending a great deal of our time with an election reform project trying to deal with another element, the very legitimacy of our election process, which, of course, is fundamental to the system, to come back and do another version of the Help America Vote Act. And it's clearly got to take into account the fact that having private vendors in a profit-making process in the election machine world where you don't have a real marketplace. It's a very different kind of marketplace. We're going to have to rethink that process and probably do it pretty quickly.
Let me just add one point, slight elaboration or even extension of what Norm said. There have been statements at the beginning of the Clinton administration, then statements by legal experts who had served in this administration who laid out a constitutional rationale for presidential signing statements, which began virtually after the birth of our republic. Sometimes they're just simply explicating what the president interprets to be the meaning of the legislation. Sometimes it's sort of sending a clear signal to other administrative agencies of how to enforce it and implement it. But there are times, especially with large omnibus bills, where there are small components that seem to trespass on, say, a president's diplomatic powers, which is clearly lodged in the Constitution. If a president believes that a particular provision is unconstitutional and makes an explicit case for that, and it is generally accepted in the legal and policy community, then they would argue you don't have to veto the whole bill to ignore that piece of it. And then the Congress, you make that explicit, the Congress has the ability to come back, to alter the law, to insist that, no, you've interpreted this wrongly. But those provisions are there, and you could argue the president has a constitutional responsibility to make that clear. The problem under Bush came because he was making unusual and extraordinary constitutional assertions about the inherent powers of the presidency that were highly contested and had few parallels. Some of them would have made Alexander Hamilton blush, who was a strong proponent of a robust presidency and executive branch. So much of it goes to the substance of the argument being made, as well as the form itself.
Good afternoon, gentlemen. Thank you for coming here. And my question is, basically, how are we supposed to keep faith in a document like the Constitution when it seems like decisions like Heller versus D.C. came outright and called the D.C. gun bans unconstitutional over 15 months ago and seemed to have no effect? We see local and state governments all around the country disregarding the Second Amendment in places like San Francisco, Chicago, New York, D.C. Basically, what I'm trying to say is it seems like we're so powerless as a society to stop laws that seem to directly attack our rights to keep and bear arms. And how are we supposed to stop them? If we're powerless on this issue, how are we supposed to stop attacks on our other constitutional rights down the road?
Well, who wants to go first? I think Norman should go first, don't you?
Actually, the fact that you should feel heartened with the fact that the Supreme Court decided it would take up the D.C. case and would have a vigorous argument over the meaning of the Second Amendment, and then come down with its own pretty firm conclusion. And that firm conclusion was that the militia clause really was not the operative one. Now that doesn't mean, and the court itself didn't say that you could have no gun control, but it created a different dynamic in that process now. Things move fairly slowly, and even on the Supreme Court, the most ardent proponents of the Second Amendment as that's defined, as you, I think, would want to define it, didn't say that that would give everybody the right to have a bazooka or a suitcase nuclear bomb, even if you could conceal it, to walk around. But it takes a little while before you figure out how you can operationalize these things. Inside Congress, there has been a vigorous debate over an amendment offered by Senator John Thune of South Dakota, which would have the federal government step in and basically supersede all state and local laws to allow the loosest provisions for concealed weapons and other things, which is a kind of curious position for somebody who otherwise professes a total fealty to the 10th Amendment and federalism, and the federal government shouldn't be stepping in to trample all over the states. But that in turn led our friend and colleague E.J. Dionne to suggest that there was great merit in what Senator Thune was trying to do. In the first place to make it work was inside Congress. Have everybody allowed to have concealed weapons walking through the Capitol. And if that's going to make us more safe, then let them do it on themselves, which they somehow decided they didn't want to do. But we're clearly moving in a very vigorous debate, and one could argue a very healthy debate over what the meaning of the Second Amendment is. So I wouldn't feel disheartened if I were you.
Indeed, Norman is right. I'd just add that all of our, quote, rights in the Constitution, and which are not just in the Bill of Rights, but built into the structure of the Constitution, are sometimes in conflict with one another and require a balancing of interest. It's true of free speech. It's true of the religion clauses in the First Amendment. It's true of the Second Amendment, and the possibilities of engaging in some kind of regulation and restriction on behalf of public safety. Let me just tell you, I was stunned by one thing that happened during the summer. The president went, I think it was to Arizona, correct me if I'm wrong, to do a town hall meeting, and outside, I think within firing range of an AK-47 or whatever it was, individual citizens showed up with that weapon loaded. And it was clearly in full view of various security officials, but it wasn't confiscated. I had assumed that the Secret Service had the authority under its mandate to protect the President of the United States to see that people with concealed or publicly revealed weapons would not get within firing range of the President of the United States. But I guess I was wrong, Norman, huh?
That is quite a stunning development, actually.
So there are a balancing of interest.
You don't have an AK-47 with you. Just checking.
So let me turn it over to John to close it out, but thank you, gentlemen, so much.
Thank you very much, Alicia. I'm John Bradamus, 3rd Congressional District of Indiana. I simply want to say what a brilliant discussion the two of you have given us today. And I'm greatly honored, as are all of us at New York University and with our Center for the Study of Congress, that you should have joined us today. And I'm pleased to understand that we have taped your discussion, and I hope that we can take advantage of that fact to give even a wider impact to what you've had to say. So I want to, on behalf of the university and myself and the Bradamus Center for the Study of Congress, to express deep appreciation. And Mr. Speaker, I yield back the balance of my time.